Hello, everybody. I'm Professor Andrew Sermani, and Dr. Baker asked me to talk to your conducting class. You are so lucky to have Dr. Baker as a professor. She is a very passionate teacher. She cares so much about her students, and she is a great educator who has a lot of experience inspiring young, impressionable minds. And she's also a fantastic colleague to work with in the CSUN music department. So you're very lucky to have her. So here I am. I'm reporting here from the San Francisco Bay Area because I grew up in Oakland, California. And, you know, you could take the boy out of Oakland, but you can't take the Oakland out of the boy. So I left my heart in San Francisco. Okay, moving on to the topic at hand here. Copyright Basics for Music Educators and Directors. And this is a book that I co-wrote with Pam Phillips on this topic that you can find on Amazon or any of your local retailers, wherever you order from, Pepper or Stanton's or anything. Okay, so let's talk about copyright basics first. What is the definition of a copyright? I'm waiting for the answer. It's the right to copy. And what are the rights granted in the copyright to the copyright holder? Section 106 of the U.S. Copyright Act of 1976 states, number one, the right to reproduce the work. Once again, these are the rights that the copyright owner controls. Number one, the right to reproduce the work. Number two, the right to distribute copies of the work. Number three, the right to perform the work publicly. And number four, to make derivative works. Number five, the right to display the work publicly, more for paintings and statues, etc. And then number six is a new one that came about in the 90s. In the case of sound recordings, the right to perform the copyrighted work publicly by of a digital audio transmission. That gets a little complicated, but basically royalties are not paid to artists and record labels when songs are performed on the radio, but they are paid to the publisher and to the composer, but not to the artist and to the label. So good example there is Whitney Houston singing I Will Always Love You on the Kiss FM radio. And she's not making any money, or actually her estate is not making any money. But Dolly Parton is making money because she wrote the song, and Dolly Parton's publisher is making the money. But with this new law, if it's broadcast on Sirius XM radio or Pandora, because it's a digital audio transmission, then artists and sound recording owners are making money now. And they've paid out $7 billion since this law came into place. So it's a big deal now. Most everything's digital now. Okay, so in terms of a copyright, you have to make the difference between an intangible property versus a physical property. So the difference is songs on the record versus the physical record. I still have a lot of records, even 78s, I have those. But I don't own the songs on those records. I just own the physical records or the physical CDs. And I even have tapes. I might even have 8-track tapes. I don't know. I have to dig through my garage, you know, because I'm old. But anyway, so I own the physical record, but I don't own the songs. So same thing with a book. I own several books. There are many books in my library. I own those books, but I don't own the publishing rights. So I own the physical property, not the intangible property. So very quickly, history of U.S. copyright law. Article 1, Section 8 of the USA Constitution, 1787. You know, our country was founded in 1776, and then we have the Constitution, 1787. And the specific language in Article 1, Section 8 of the Constitution says, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So first of all, it says useful arts as opposed to non-useful arts. So, you know, high arts, and it also says for limited times. It doesn't say forever. It's for a limited time for authors, inventors, and it says exclusive, the exclusive right to their respective writings and discoveries. So why was that put in place? The founding fathers felt that to promote the progress of science and useful arts, if there's a financial incentive for someone to benefit from them personally, as opposed to just the state owning their copyrights, then it's going to create a lot of creative works. And you know what? They were absolutely right. But we don't want to lock it up forever. So there's a limited time where you get to benefit. In the early days, it was a very short time. It's a longer time now. So what else is in Article 1, Section 8 of the US Constitution? Some very important things. It laid out the powers of Congress and the legislative branch. It talks about borrowing money and regulating commerce. It gives the rules of naturalization. It establishes the post office. It gave Congress the ability to form armies and navies and declare war, to make laws to enforce the Constitution, and to promote science and useful arts. So science and useful arts were up there with all those other really major things. It was that important to the founding fathers that it was part of our Constitution. Okay, there were other copyright acts in 1831, 1909, but let's just go to 1976. Sound recordings get defined as original works of authorship comprising of an aggregate of musical, spoken, or other sounds that have been fixed in tangible form. Phonorecords are defined as physical objects in which sounds are fixed, records and tapes. And publication is defined as distribution to the public. And it also spelled out fair use, which is an important concept, especially for music educators. Okay. So at the time in 1976, when this act went into place, into effect on January 1st, 1978, it was life of the composer plus 50 years. So that changes later, but at that time it was life of the composer plus 50 years. In other words, it's making money after the composer dies. So their estate and family are making money off their copyrights. It also brought in protection to works not published, but in fixed form, those without copyright notices. And that's very important too, because you don't have a copyright if it's just in your brain and it's just a thought or an idea. But once you put it down in a fixed, tangible form, a printed piece of music or a recording, you have a copyright, even without registering it at the Copyright Office or registering it with a performing rights organization. Rights of termination, also something new. 35 years after transfer, which begins in 2013, when you compose something, you have a copyright at that moment. If you in turn pass on that copyright to a music publisher like Warner Chappell or Sony ATV or Universal Music, you are making a transfer. It was yours because you created it, you make a transfer. Well, you have the right to terminate that 35 years after you make that transfer. So since that went into effect in 1978, the first time this came into play was 2013. And you know what? Many authors have terminated their transfers. Okay, the law went into effect January 1st, 1978. Okay, so after that, 10 years later, we had the Berne Convention Act of 1988. It was not necessary to have the copyright notice on the work. The work does not need to be registered, but you must register it in order to file an infringement claim. You don't have to register it, but this is very important because if you're going to try to sue someone for stealing your copyright, then you have the authority to file an infringement claim. And we're talking about registering with the Copyright Office, copyright.gov. Transfer of copyright ownership not required to be registered with the Copyright Office. If you choose to sell your copyrights because you want to make money from them, which many people do, right now, you don't have to register that copyright. But once again, if it's registered, all the evidence and proof is there. And public domain, also known as PD songs in the US, could become protected. All right, so this is very important. The Copyright Term Extension Act of 1998. All right, would you like to take a guess who was behind this act? A member of Congress who was a famous singer of a duo group in the 60s and 70s. You give up? Sonny Bono. The Sonny Bono Act. You know, Sonny Bono was a congressman. And he pushed for this, which extended the term of the copyright. So increased the total term of all works under copyright protection as of January 1st, 1999 by 20 additional years. So now, and the main reason of this was to align the USA with the European Union. So now works published after December 31st, 1977, which is January 1st, 1978 or later, are protected for 70 years after the death of the composer. There was a time when copyrights would expire during a composer's lifetime. It used to be 14 years and could be renewed for another 14 years. That means they're still alive and the copyrights expired. Well, that doesn't exist more. 70 years after the death means you can make a lot of money for your family after you're dead, if if that's important to you. Okay. Acts addressing digital. So we have a couple acts that address digital. One is the 1995 Digital Performance Right in a Sound Recording Act. The rights to perform sound recordings digitally. And this is for non-subscription broadcasts. They're exempt. The non-subscription broadcasts are exempt, and non-interactive internet to pay a statutory license fee. And interactive internet services need to negotiate a fee with the copyright holder. And then we have the 1998 Digital Millennium Copyright Act. Internet service providers are exempt from liability. So this was signed into law by President Clinton. It implements the WIPO, World Intellectual Property Organization treaties of 1996, and it criminalizes use of technology to bypass digital rights management. And the internet service providers are exempt from direct and indirect liability. All right, work for hire. Owned and controlled by the employer. The employer is the copyright owner. For example, Walt Disney, the Sherman Brothers went to work with their lunch at the Walt Disney Company, and then they wrote Mary Poppins, and then they went home, and Disney owned the copyright. This lasts for 95 years from publication or 120 years from creation, whichever comes first. Fair use. Section 107 of the U.S. Copyright Act of 1976. The purpose and character of the use, this is what determines whether it's fair use. In other words, you can use it without worrying about copyright infringement. So the first thing is the purpose and character of the use. Is it commercial or nonprofit? The nature of the copyrighted work. Number 3, the amount and substantiality of the portion used in relation to the copyrighted work, and the effect of use upon the copyrighted work. In other words, are they going to lose sales by allowing this use? So here are some examples. Quotation of excerpts in a review. Quotation in scholarly or technical work. Use in a parody. Summary in a news report. Reproduction by a library to replace part of a damaged copy. Reproduction by a teacher student for a lesson in our class. All right, print music and lyrics. They're controlled by what are known as print music publishers. These are companies like Hal Leonard, Alfred Music, Word, Lorenz, Hope, Chose, etc. Carl Fisher. That's where they control the rights to print. So if you need to do an arrangement or you need permission for anything, you would reach out to those companies. And they represent the rights of others. For example, Hal Leonard represents Sony ATV and Universal and Disney and some Warner Chappell, and Alfred has Warner Chappell and some other catalogs. Audio. Mechanical license is needed, and it's very easy to get. It's a strange term because it used to refer to mechanically reproducing a song on a piano roll, and the term has kept to this day and age, even though everything's being done digitally now. But it's very easy to get through the Harry Fox agency. You go to harryfox.com. So if you're going to put a copyrighted song on your recording, you secure a mechanical license and you pay a fee, and then you're allowed to do that, like a cover tune. So we can all release our own Beatles albums if we want to, as long as we secure the mechanical licenses, and they cannot be denied. They're compulsory. The right to use a master, there's two rights in a sound recording. One is the actual recording itself, called the sound recording copyright, or the master recording right. And the other one is the composition on the song. And also, posting audio online, that is a reproduction, so you need permission for that. And producing CDs or digital files of your group, same thing. You have to pay mechanicals for those. There are third-party aggregators like TuneCore and CD Baby. There are ways to get these done and secure licenses and get your stuff on all the digital platforms. So mechanical licenses, they're compulsory. It's a compulsory license if the work has already been recorded and distributed to the public. And the cost is 9.1 cents per composition, or up to 5 minutes, or 1.75 cents per minute over 5 minutes. So that's the pricing there. And Harry Fox is the place to get it. As far as video, because you're synchronizing music with video images, you need a synchronization license. They're not compulsory. They can be denied. And you need permission from everybody who owns a piece of that copyright, even if it's 1%. You secure this directly from the publisher. Harry Fox does have an eSync service you can try to use. And the fees charged depend on the importance of the composition. I mean, you want to use Yesterday from the Beatles, that's going to be a lot of money. And it could be denied. The type of use, the length of the composition, and video recording concerts. Once again, you do need sync licenses to post those anywhere, even online. And same thing with YouTube. YouTube is not clear. You don't, just because you stick it up on YouTube and because there's millions and billions of videos up there, doesn't mean it's cleared for sync usage. You have to get clearance from the publisher. And they put digital fingerprinting in some tunes to basically find recognition and find those videos up online. If you want to show a movie, a real movie in your class, say during a class during a rainy day or whatever, you're going to need to get a license from the Motion Picture Licensing Corporation, the MPLC, and they're pretty reasonable. If you do post a video on YouTube and then you see this, that means it was taken down because of copyright violations. So you don't want to get that. And by the way, if you get, you can get strikes against your channel if you violate copyright, and it's like 3 strikes and then they take your channel down. So you have to be careful of that. Digital products and the internet, be careful of what you download. There's a site called IMSLP. It does not necessarily mean that everything is public domain on that side. Be very careful. For churches, there's a wonderful service called CCLI. You don't have to pay a license to perform music in a church service. However, churches do a lot of extra things beyond this. They print lyrics in their bulletins. They make rehearsal tapes. They do live streaming. They do a lot of extra stuff that falls outside of fair use. So what they need is to get signed up and registered with the Christian Copyright Licensing International, a great organization, and it allows all kinds of uses for all different types of religious institutions. You don't even have to be a church. Temples can be on there too, but it's a great organization. All right, performance rights. This is, what is a performance right? Venues who perform music, either recorded music or live music, are responsible for securing those licenses. Now, there are exemptions for restaurants of less than 3,750 square feet and businesses less than 2,000 square feet, negotiated by the Restaurant Owners Association, of course, but that is an exemption. And the exemptions do exist for face-to-face instruction, like in our classes, and as I said, religious assembly, and then elementary and secondary school is exempt. So for food and drink businesses, either the business must have less than, we said 3,750, or if the business is more than that, uses a maximum of 6 speakers, all this kind of stuff. But the point is, you need a performance license. What these venues or these businesses or whatever, they go and they get blanket licenses from the performing rights organizations like ASCAP, BMI, CSAC, GMR, and they allow them to play the music in their venue. Composing and arranging. A derivative work is controlled by the publisher. One of the rights of the publisher is the right to create derivative works. You can't do that without their permission. And that includes simplifying or editing or arranging. It's even if you simplify for your group, that is considered a derivative work. When does something become copyrighted? And then, of course, copyright registration. Like I said, you don't have to register, but it's highly recommended. And of course, public domain is like classical music that's fallen out of, and this is basically stuff before 1924. For a while there, Warner Chappell was holding on to Happy Birthday, and finally, after several challenges, they won and showed that it really was a public domain. So luckily they had kept $1 million in trust, and they finally ended up having to pay that out. Teaching, arranging in a class, that would be okay. And cover tune, as I said, anybody can make a cover tune as long as you get a mechanical license and you pay the license, and that's to put the cover tune on a recording. That's what the mechanicals used for. And, you know, keeping it basically the same it is, you know, without making changes is a cover. But if you change the basic character, including putting a different language on there, that is considered an arrangement. Steps in preparing an arrangement for a copyrighted tune. Once again, you need permission before you do that, and then you get the license, and then you're able to do that. How composers, lyricists, arrangers and get paid. They get paid in a lot of different ways, from the sales of print, from the sales of recordings, from performances of their music. There's a lot of different revenue streams coming from all the rights that related to copyright. And you've got traditional publishers like Universal Music and their print publishers. So Hal Leonard doesn't own those Universal Music copyrights, even though they release tons of books with Universal Music copyrights in them. They have the print license, and then they pay the royalties to the publisher. Submitting compositions to print publishers, you're welcome to do it. Some of them don't accept unsolicited manuscripts. It's very difficult to get them done there. But there are a couple services that you can use where you can sell your own print music online. One through J.W. Pepper called MyScore, and another one through S&P Press, which is owned by Hal Leonard. And they even have the ability to use up to 1.25 million copyrighted songs. So if you want to do your 6-bassoon arrangement of Bugler's Holiday, there's a good chance you won't have a problem getting that cleared and being able to sold on that site. Okay, Q&A. Is it out of print? Is an out of print work still copyrighted? Yes, it can be. Yeah, just because it's out of print doesn't mean it's copyrighted. Can I copy scores for a competition? Only with permission from the publisher. Does fair use apply to performing during worship service? Yes, but there are specific guidelines, as we discussed earlier. Why should I follow copyright law? It's the law, number one. It's a moral responsibility. It shows respect for fellow creative artists. It protects you from legal challenges. It speaks to your integrity as a music educator, and it promotes creativity of our musical art. All right, I hope you enjoy this. I look forward to answering. I know you have lots of questions related to this. I look forward to joining Dr. Baker's class later to answer your specific questions. And that's it for now. Now I got to go teach my other class. All right, bye.